There is a motion to modify the temporary order in this case and a motion to appraise marital property. Ms. Locke, it's your motion. What is the status of these motions?
Yes, Your Honor, we have not been able to reach a resolution, so we would like to be heard on both motions today.
All right. How can there be an objection to appraising marital property?
Okay. I think that we have resolved that, Ms. Locke. I think we will agree to use marital assets, and then we'll split them equally between the parties to pay for it. And that was the only issue. And the 10 acres to the son. We want to make sure the 10 acres to the son, we understand the parties have agreed and they are not being included in the appraisal. So if we have an agreement on those terms, this is not an issue.
Yes, there's
Ms.
an
Locke?
agreement.
Okay. Okay, so who's going to submit the order? Because
will
there's additional conditions, so I want an order on it.
I will do that.
Okay. Can 10 acres do you any good in Butler County? You got to have 40 acres to build anything unless you get an exemption from the county commission. Unless it's not in Butler County.
And registered with the deeds.
Okay. I understand it's already been surveyed and registered with the deed, so we have already taken action on the 10 acres.
Okay. Okay. Your client is the plaintiff, Ms. Locke.
Yes, Your Honor, the petition. Correct.
She filed the order. And she
She
filed the
did.
temporary, but she wants to modify
Yes.
it. All right, you may proceed.
Your Honor, when this case was first filed, we believed that the parties were in agreement about most of how the case would transpire. And we find ourselves months down the road without reaching much of any resolutions. When my client first filed, she agreed to vacate the marital residence and live temporarily with family friends in Topeka. Her situation has changed due to the length that the case has been pending, and she had to seek alternative housing options closer and in Wichita. That has necessitated her needing spousal maintenance. Prior to the separation, the parties agreed to split their excess income monthly equally, which resulted in them each having about $800 in discretionary income after things were paid at the household. When she filed for separation, that $800 continued to come to her. However, there's a huge disparity in monthly income, and now that we haven't reached resolutions, she needs some additional monthly income in order to be able to survive. Ms. Sawyer gets about $1,000 a month from Social Security. Mr. Sawyer gets about $6,800 a month in monthly income between his pensions and then his Social Security payments. He has been responsible for several of the bills. The largest bill that he is responsible for in the temporary order, other than the mortgage on the marital residence, is my client's car payment. And I will give the court a little bit of history on that. The parties sold off some pretty significant acreage not long ago after she purchased her car. At closing, Mr. Sawyer elected to pay off his truck and some other equipment that's at the marital home and opted to keep her car loan because it had a low interest rate. At that point, he agreed to continue to pay her monthly car payment and has continued to pay her monthly car payment despite there being funds at closing to pay off her car in full. So at this point, he pays her monthly car payment, and then they divide that extra $1,600 a month, giving her a total monthly income of about $1,800 to his $6,000. So what we're asking the court to do today is to make that a little bit more equitable. Essentially, we're asking the court to give her approximately one half of his, one of his pensions monthly, which we believe will be close to what the final outcome is in this case. So we're asking the court to award her formally $1,800 a month in spousal maintenance, which is in our motion. We believe this is supported by the factors. Both parties are retired. He lives in the marital residence. He has more discretionary income. He has more regular monthly income, and he has the ability to cut some of his bills back, including internet, cable, things of that nature. My client needs to be able to survive in a new rental in Wichita until this case is resolved. She has no access to any additional income. All of those items are held by the respondent in this case. So we're asking the court to award her formally $1,800 a month in spousal maintenance.
All right, 1982. That makes this about a 43-year marriage
Yes, Your Honor.
as of yesterday. Mr. Morgan, your client hasn't filed a domestic relations affidavit that I can see.
Yes, we have, Your Honor. I will
Okay.
show you. Oh, can I share screen?
Sure. What, can you give me the date so I can try to find it?
Oh, I think it was either last week or the week before that.
Okay, well, it's not in the court file. Okay, here we go. I got the response. You may
Okay.
proceed.
In the first paragraph, I point out that here's what he's paying for the petitioner. Car insurance, $50, car payment, $435, cell phone, $85, okay? And he has paid her $800 a month. And this is a total of $1,370 per month. All right. Now we're asking the court to just keep it the same because we believe that this makes everything, the net incomes of the parties equal. And we believe that that's the fair way to do it. Okay, we go on to our next paragraph, number 2. We did send an email to council. We were a little late on the DRA, but 2 months ago, we outlined this and we said, here's his income, 680. He pays bills. This leaves 260. We pay her 800. He keeps 800 and their net incomes are the same. And that's what we've been doing. And that's what we believe the court should continue doing. All right, paragraph 3, the DRA we submitted for Mr. Sawyer supports those statements. He does not have the financial ability to pay any more. And if the court does increase the spousal maintenance above what this is now, we request the court to shift her expenses back to her. And that would be the cell phone, the car insurance, and the car payment. Now, that just involves a lot of work and shifting. We don't think it's necessary. That's why we believe we should continue as is.
Okay,
All right, now let's go to his DRA.
okay.
We'll pull that up.
Well, my impression is that she will, if she got the 1,800, she would do the 85 cell phone and car insurance, but the car payment is in dispute because he just took that on as his debt when at least, I mean, if his truck was paid off, he could have paid off half her car and half his car and reduced what was owed for both of them for purposes of moving forward. But if he took the money and just paid off his truck and chose not to pay off her vehicle,
yes, but we're getting down to, go ahead.
well, I think she understood that to be the agreement. He was going to keep making her car payment for her.
Well, regardless whose debt it is, he has to pay it, and that reduces his net income. And that's what our DRA shows.
Okay, let's go through that.
Let's go through his DRA.
Why? We borrowed money against my truck. My truck was already paid off. We borrowed against it. Her car, we borrowed against it. We paid off the truck we borrowed against her.
Okay. Right. All right. Let's go to page number 1, paragraph 9. It shows incomes. It shows his income. We've attached a statement thoroughly analyzing it and going through all the net. His income is basically 6,800. Her income, we believe, is 1,038. If you go below that, and then we go down to paragraph 11.
Now it's the husband's turn, fighting back with cold, hard numbers.
This outlines his living expenses. All right. Now, if you go back to my email, these all correlate exactly. And if anything, if you go through his expenses are a little bit light. Of course, the cell phone includes her expense, and the car insurance includes her expense. You go through that, we spend a lot of time on all these. And what's significant is he puts all of his expenses on a credit card. And we listed the credit card, but we didn't put the payment in because that would be a double dip. He puts everything on his credit card, and we have submitted those documents to the opposition to show his
Okay.
spending.
Okay,
All right.
well, that's great. That really shows what he's doing with his money. Why is his, are they all electric? Why is his electric bill $400?
It just is, it's a pretty big house, and it's not that efficient, apparently.
Yeah,
What?
it's a big house and it's not that efficient, but you know, the records show that that's what he's spending. Now, another thing the court should take note of is when we go to paragraph 12 on our DRA, the house payment is $2,500. And that is a large house payment for these parties, but somebody's got to pay it. So
Well, not really. I mean, right now, yeah, but somebody doesn't have to keep it. They can both downsize, sell the house and find something else, but.
Oh, no, we agree with Your Honor on that. And
Okay,
that could be a way to resolve this, but for
Okay.
right now, he's got to make these payments. He makes the house payment, the car payment. You know, when you look at this, it really doesn't matter. Well, is it her car, his car? It doesn't make any difference. He's got to make the payment. All right. If you go down, he has a credit card of $40. He pays the Amazon Chase credit card of $125. He believes he is now with Amazon and both parties contribute to it. He is paying that credit card every month. So she does get a benefit there. If you total all these up, if you look at his income, his net, all of his expenses, his net balance is 632. If he pays her 800, he's 168 in the hole. So that's why we believe this is fair. He pays her 800. He pays those three expenses. He gives her, and when he does that, she has a net amount, which is basically the same as his. All right, now let's go to her DRA. And that would be our Exhibit E.
all right, hang on a minute. What makes him think that he needs $500 a month for hobbies and entertainment?
Because that, you know, it's kind of hard to describe, but that is anything that he does. That's anything and everything he does outside of that house. He
Okay,
does play a little golf. He does do things with his family. He might go do this or do that. And that means he only spends $125 a week on activities, and that includes everything he does. So if you look at it that way, that's really a pretty low amount. To restrict that down means a person basically couldn't do anything outside of their house other than hike and walk at no expense.
okay.
And we're
Well,
still at a whole.
Just if you did a quadro on the Teamsters, she's looking at getting $1,348 a month.
I just think that that's something we can look at in the final resolution. But right
Well, I
now,
think the parties ought to start getting into a posture absent the house where they know what they're each going to be working with monthly.
well, that's a good suggestion. And we can't work toward that. But right now, if he gets hit with that much and has to pay all his expenses, he will not be able to do it. He simply will not be able to do it. All right,
The judge steps in hard, grilling them on debts and expenses.
let's go through her.
How old is your client?
75.
75.
Oh, wow, okay. Ms. Locke, how old is your client?
She is 70, Your Honor.
Well, they both look good and they both look healthy. All right, go ahead, Mr. Morgan.
Okay, if we look at the petitioner's DRA, rent is $1,000. We don't know, we have no documentation for that amount. Okay, I'm gonna let the court find it there. It's our exhibit E.
Okay. Hey, by the way, what's the interest rate at through Members Mortgage, White Eagle Credit Union?
2.5%.
Okay, well, you can't do any better than that.
No,
All right, let me
Yeah.
get to E.
And Your Honor, you had a question earlier, and I just have a clarifying point on it before Mr. Morgan continues. It is a house and 120 acres that's covered by the mortgage payment, is
Right.
my client.
Well, I was trying to figure out if they sold off some, was that separate? That was that some other property?
There was sufficient equity on the house and 120 acres for them to be able to sell a portion of it.
Okay, so the mortgage company released it and gave them permission to sell it.
yes,
And
Yes,
have they released it and gave them permission to deed 10 acres, give 10 acres to their son?
yes.
Yes.
Okay.
There's,
Because
we're imagining there'll be
careful
some
with the
significant.
acreage, you reduce the value of your overall residence by having some weird acreage amount.
yeah,
mean,
I-
Usually
we
it's
haven't
in
looked into
parcels.
that, but we will, and that will be part of the appraisal that we're gonna do, is to have somebody assess this land and the house and give them possibly some pointers on what to do and how to do it.
Well, I'm not trying to be mean, but I don't know that I have to approve them gifting 10 acres to their son if neither one of them have enough money to live on.
Well, that
Why
is the
am I not
court's,
finding E? E is the petitioner's revised
the
amendment.
revised
I have
DRA.
that right here, so I'll just look at it in here. I would be interested in seeing his credit card statements that are a good reflection of what he's doing monthly, but if you don't mind, but I'm looking at the revised domestic relations affidavit right now.
Okay, if you go to paragraph 12,
Okay,
the rent, we don't have any kind of document to support that, but it's not terribly high. But what we do question is line number 4 for health insurance. She's on Medicare. They're both on the same Medicare plans. They should have no out-of-pocket expense for healthcare at all. That would take $224 off of her DRA. Okay,
well, you gotta pay for supplemental.
well,
And usually out of your social security comes your Medicare Part B.
okay, and Your
It
Honor,
reduces your social security. So
and
you do pay. I mean, my husband pays $500 a month to have Medicare.
okay, and if we, in our exhibits, we have her social security statement, and what it is the amount of income has already
Okay,
taken.
let me look at her social security statement. I'm sorry.
It's exhibit I.
Okay,
And Your Honor, just for the record, we received these exhibits yesterday afternoon. And so I did not have the opportunity to discuss them with my client in advance of the hearing.
okay. Well, I may end up having to take this under advisement anyway, because I'll be frank, I have cases set every 30 minutes today.
Well, do you have time
Can you
next?
give me the bait stamp number? That'd be a whole lot faster for me. There's bait stamp 34.
34.
All right.
We
I'm
could do
looking
this
at
next
it.
week, Your Honor, if you have time.
I don't know if I do or not. If I have a
Okay.
jury trial, no. If I don't have a jury trial, I may. But I won't know that till Friday.
But what it is
Go
we're using their nets, and if you see over to the left, it says Medicare Part B taken out. We've allowed that to be taken out. So there should be no expense for health insurance. And under his DRA, if you look at his, he puts in no expense for health insurance.
Here comes the bombshell. The house value could change it all.
It's a Medicare Advantage plan. There's no monthly payments.
Yeah.
Oh, so you're saying, goodness, she only gets 14,312.40 a year.
From Social Security, yes.
Right, so you're saying that the $1,100 that's been put, that you put down as her income already deducts the Part B.
Yes, and there
Okay.
is no monthly expense for Medicare.
Advantage.
Well, you got a
Advantage.
supplement.
Okay,
No.
well, no, that's it.
They
Right
don't have the
there,
supplement.
Medicare Part B.
Okay, no supplement.
And that's same with him. And you can see that's why he does not have a health insurance expense on his DRA.
Okay.
Okay, back to her.
Then they're gonna be paying for all their own dental and eye and, okay, back to what?
Her revised DRA.
Okay. I'm there.
Okay, I was at health, and that's where we,
But what if that's prescriptions, dental appointments, eye appointments?
Well,
I
it
mean,
does,
what if they
there's,
doing on prescriptions?
we don't know, but there is a line there for medical, dental, vision expenses, and there, it's zero. We
Okay,
just don't know, but we
Okay.
don't know of any monthly healthcare cost for that
Okay.
amount. All right, and
Okay.
we have not put any amount in those areas.
Okay, okay.
All right, and then finally, if you look down at number 15,
I guess she does have $20 for prescriptions.
yeah,
Okay. I'm
All
looking
right.
at 15.
you can look at his too. He's not trying to put amounts in for him that we don't believe should be put in for her. Then at the bottom, it's a BOA credit card, an Amazon credit card. You saw that he paid an Amazon credit card. We believe that we are covering some of her Amazon expenses. We do not know what these are. We believe that these are post-filing expenses. These are not expenses that existed prior to the filing, and we don't know, we don't have a basis for them, and we don't think they should be on her DRA. All right.
Okay.
Now,
So
if you
you're
go to the next,
basically disputing $624 that she says she needs that she doesn't.
true. And if
Okay.
you go to the next page at capital paragraph C, total living expenses.
Okay.
Net with their proposal is 487, more than what she needs. And if you looked at our net, he was in a deficit of 168 after paying her 800. So when you look at this, you look at the expenses at issue, you look at this, we simply don't believe that there's a need for $1,800 based on our setup. We give her 800, we pay the 3 expenses, and that's where we are. She's got an excess of 487. She's got question expenses of around 600. He's outlined all of his expenses. He's at a deficit, and that's why we believe we should carry on the same way as we have done.
May I briefly
Now-
respond, Your Honor?
Now,
Yes.
let me,
Yes, go ahead and finish. I need you to finish up, Mr. Morgan.
that's all right, I'm getting there.
All right.
And if it does increase, we need to move some expenses over to her to make it fair. Now, if you look at the, I don't know, sometimes we use a spousal maintenance equation. If you look at his gross, her gross, you take it by 20%. That amount I figured out today was $1,386. And right now it's 1,370. So even with the standard 20% equation, our number is almost right on it. So for all those reasons, and we can send you his credit card bills. We've sent it to the other side. If they had a problem, we would just anticipate that they could show that to the court. But if the court wants to see those credit cards to substantiate his spending, we can send the court those. All right, that's all I have. Thank you.
Okay, thank you.
And one
did
last
you-
thing though, we are dividing income in the end is part of the overall settlement. Okay, but right now with the payment of expenses, the mortgage, I don't think it will work as a way to resolve this on a temporary basis.
Why can't you get to a settlement? Because of the house?
Well, after we get it appraised and he can look into refinancing, then
I mean, but
that's
this has been on file for 6 months. What's the tax value by the county?
Good question. Tax values.
The challenge, Your Honor, is it would be a ag value for the acreage.
Right,
She's asking the taxes.
What's the address?
do you know if you tried to split up 40 acres to sell
Yeah.
separately, whether you'd have a landlocked situation, Ms. Locke?
I don't know, Your Honor.
Okay,
Or
Yeah, and we don't know that either.
Okay.
Yeah, it's only been 4 months and they have worked on things. They have made an exchange of personal property. Their son is involved with some financing and payments on a house. There are other things that we have looked at and resolved that are not before the court today. So we haven't just been sitting doing nothing.
okay.
Your-
Well, I'm
Your
not
Honor,
suggesting that you have. I'm not suggesting that. What is the tax value? Do you know? Did you get a tax
Yes.
statement?
Yes. Yes, Your Honor, the tax value for the house is $260,000. The tax land market value for the acreage is $324,000. But it's taxed at ag, so it's
600, what I would say.
not taxed for that.
We would think a ballpark is around 600,000
Okay.
and the mortgage is 200,000.
So you're looking at 400,000. So that's what they need to get busy with. So it'll solve all their problems.
May I respond, Your Honor, briefly
Yes,
to Mr.
yes,
Morgan?
yes.
So, Your Honor, our challenge is that Mr. Sawyer has not had to change his lifestyle in any way. He continues to live at the marital residence. He continues to do all of the things that he has previously done in retirement, golf, etc. And Miss Morgan left the home by agreement of the parties and now needs somewhere to live, and she needs the ability to sustain that. Mr. Morgan makes it sound like we've been withholding information. He has not issued any discovery, so we have had no requirement to provide any documents, nor has he asked for anything that we would
Okay.
have
I
voluntarily
understand. I
given.
understand. I need you to look over his exhibits and we're gonna come back next week. And I'm gonna take it under advisement and I want to see his credit card bills for at least the last 6 months to a year.
Your Honor, something significant for the court to consider when taking it under advisement
Okay.
is the adult son lives with Mr. Sawyer. He could be easily sharing in the household expenses, but he chooses to allow him to live there, from my understanding, for free, which is not conducive to the parties dividing their property equally. So if he's going to have a roommate, the roommate needs to share in the expenses in the same way that Miss Sawyer would be obligated.
I
if she
assume
had.
this is their son together.
Correct. It's their adult child, very
Right.
much an adult capable of paying his fair share of household expenses.
Okay. Do they just have one child together?
No, Your Honor, they have 2 children together.
Okay. And how old is the son?
42. He's 42 years old.
Does he have any mental disabilities, drug addiction, anything
No.
like that? Okay.
No, Your Honor.
But he may help mow or do stuff, maybe, I would hope. But-
You'll see lawn
Answer-
maintenance as an expense of Mr. Sawyer and his DRA.
Right. Ms. Locke, tell me what they're doing with this acreage. Is somebody farming it and they're making proceeds from it? Are they farming it? I mean, what are they doing with this land?
Just owning it.
It's just something to look at, Your Honor.
There's no,
That's a lot of land to look at.
We used to have a business, but no longer do.
Okay. All right. So, Ms. Locke, I'm gonna give you until Friday to respond to his exhibits specifically, not to raise new arguments but to give a written response to his exhibits, since you just got them yesterday. And then, let's see what we can do next week.
Her fight for survival, income, and fairness strikes the heart of the case with raw emotion.
Okay, I've already backed in Thursday afternoon, even if I have a jury trial. Wednesday's my duty day if I have a jury trial. The jury trial will be over in Elk or Greenwood County if I have one, which I might. And backing it in Thursday morning is iffy. Is this ruling that I have on Whitaker on the 25th, is that in person in Greenwood or am I?
That
That's
case is the one that
Judge
you
Ricky's
recused from.
What?
You
It's on
recused.
Judge Ricky's docket.
That was the recusal just before you left.
Okay, so I don't have anything on it.
Correct. You just have that 2 to 5 on the Blundell case.
Okay. And that is that in person?
Yes, and it is a Butler case.
So
Um,
I'm thinking that if possible, I'll be done with the jury and make it back to Butler for in person.
right, and I can tell you, I think at least two of those Greenwood cases should be for plea. But the Medford case, you actually have scheduled to start on Wednesday. That's Gerard Scott's case. And I think that one is supposed to be for plea. The only other one, the Delahunt case, the defense attorney has withdrawn. So I don't believe has counsel. So that would leave the Gordon and potentially the Steely case.
Okay.
So,
but
Blundell is set for motions and
well, I could rule on Friday, the 26th at 1 or 4.
I'm available at 1 p.m., Your Honor.
Mr. Morgan, can you zoom in on Friday, the 26th at 1?
You're muted, David, if you responded.
Yes, I'm sorry.
Okay,
I can do it on the 26th at 1.
okay, let's do that. And then can you give me those credit card statements? By Friday?
Yes.
Okay,
Could we at least do a short reply to Ms. Locke's response?
yes, but it needs to be due before hers is due.
Well, no. If she responds by Friday, then maybe we could do a reply by Wednesday.
I'm just submitting exhibits, correct? Responsive exhibits to their exhibit book.
Yeah,
That was my understanding.
yeah. Well, if I do that, then I need to give her a little room to make final statements on Friday. But I want you guys to stick with what you're looking at, I don't want anything new.
Fair enough.
All right, so advisement. documents and memo due Friday, the 19th. And ruling by Zoom the 26th at 1 p.m. Okay. If we can conclude at this time.
The only thing I ask, if we have anything on which today was based to submit to the court, could we do it no later than Wednesday of next week? So you have it in advance?
Yes.
All right. Both sides, equal to both
Yep,
sides.
that's always a good idea. In fact, I think we have a rule on that, and I think it's more than 48 hours, but yeah, that'd be a great idea, please.
All right, thank you.
All right, thank you. We are adjourned.
The sun's free ride and new deadlines shake the courtroom again. The judge orders proof, sets dates, and leaves everyone waiting for the final showdown. Don't forget to like this video, subscribe to the channel, and we'll see you in the next video.